Your comments, suggestion, or even where you're watching us from, we highly welcome them. And to begin our news, we begin from the Apex Court, that is the Supreme Court, where our reporter, Sarafina Robi, has been keeping tabs with the BBI appeal case at the Supreme Court. Sarafina Robi, kindly bring us up to speed with what is happening there.
Indeed, a very good afternoon, Ben Troy and Julia, coming to you live from the Supreme Court of Kenya, whereby, as you've stated, we have been following up on the hearing in regards to the Constitutional Amendment Bill 2021, which is popularly referred to as the Building Bridges Initiative, whereby today we have the hearing has kicked off with the appellants, who are the Attorney General and the Independent Electoral and Boundaries Commission, have already highlighted their submissions. But earlier on, Ben Troy, we were able to see a ruling that was delivered by the 7-judge bench in regards to time that has been sought in regards to highlighting the submissions, whereby they had sought for more time, and the Supreme Court was able to allocate them 15 more minutes. All parties were allocated 15 more minutes, which they seem to be okay with. And also all those that had said that they were willing to give their time to other parties were also allowed to do so. And thereafter also the Amici, who are the amicus curiae, who are the friends of the court, had sought to be given time to highlight their submissions, but this was not allowed. Also, Ben Troy, some of the issues that were also given in that ruling were in regards to one of the respondents, who is Felista Wekesho, a member of the Third Way Alliance, was told that she will not be able to highlight her submissions within 45 minutes, but rather her time was combined with the Third Way Alliance, whereby they will be able to highlight their submissions within 1 hour. Now, going into the highlighted submissions that were made, the first petitioner or the first appellant was the Attorney General Githu Muigai, who was represented by lead counsel, who is the Solicitor General Kennedy Ogaito. And one of the first issues that they based on was on the basic structure doctrine, whereby they were against the fact that the Court of Appeal and the High Court say that it can be applicable in the country, saying that this did not come out clearly. Now they're now seeking the Supreme Court to clarify further on matters to do with the basic structure doctrine, whereby they still oppose that it's not applicable in the country, saying that even if it was to be applicable in the country, then there will be legal and constitutional difficulty. Another issue that they were able to highlight involved whether the president can initiate a popular initiative in the country, saying that the provisions allow for every person to be able to initiate or to participate in a political process, and it does not discriminate on a private citizen, hereby regarding the president, saying that this does not discriminate the president, saying that the popular initiative route was meant also to curb the monopoly of parliament on matters constitutional amendment. Also, the other issue that was able to be highlighted on was on the issue of presidential immunity, whereby the Court of Appeal had earlier on said that proceedings can be instituted against a sitting president or someone is holding the office of the president on anything done or not done contrary to the Constitution, whereby they say then this is against the provisions on presidential immunity, since the president will be exposed to the legal process. The other issue they now say that they argue that this defeats the whole essence of immunity, as the president will have to participate in the process to prove his innocence, exposing him to legal process. The second appellant that we were able to see, who was able to highlight their submissions, was the Independent Electoral and Boundaries Commission, whereby they were led by Senior Counsel Githu Muigai, Professor Githu Muigai, and some of the issues that they were talking about in regards to the Independent Electoral and Boundaries Commission were in regards to the mandate of the IEBC and the quorum, saying that the decision that was made earlier on was premised on a law that was premised on a repealed law, and that there is no specific law on quorum, now calling upon the Supreme Court to make a ruling, or rather a judgment, that it was correct and legally capable of undertaking its constitutional and statutory mandate. These are just some of the decisions that have been able, some of the issues that have been able to be highlighted by the first two appellants in the hearing that is ongoing right now at the Supreme Court, whereby it's the Attorney General and the Independent Electoral and Boundaries Commission, and thereafter we expect to see the third appellant, who is Morara Omoki, and some of the issues that maybe we expect that he will be highlighting on are issues to do with the multiple choice referendum questions, whereby we expect to see what he will be talking about and what he seeks from this issue that had earlier on been ruled upon, or a judgment had been delivered by the Court of Appeal and also the High Court. We continue to bring you these proceedings. Right now the court has been adjourned up to 2 p.m. Back to you, Ben Troy.